Good morning.
Good morning, Your Honor. Brian Walhart of the Nashville Bar. I represent the defendant and the appellant in this case, Hamid Arab. I'd like to reserve 4 minutes for rebuttal, please.
4 minutes, yes, sir.
May it please the court, this is our appeal raising several issues of error that occurred in a bench trial arising from the parties entering into a promissory note and a subsequent modification. At the end of the day, the facts are not that complicated, but unfortunately, my position is that my client was really prejudiced due to some procedural matters that took place. The standard here is de novo unless on the record, unless the facts preponderate otherwise, and we believe they do preponderate otherwise here. But frankly, I'm not sure how we're going to be able to resolve this given the extent and the breadth and the reasons for the error, as I'll get into. As stated, this matter arose out of the entry of a promissory note and a modification, and on its face it was for $900,000. Throughout the litigation, even before my involvement as the attorney of record, defendant had taken the position that he had only received $850,000 of the $900,000. This was well known to all the parties involved in the case. As the matter approached for trial, and an order setting the case for trial was entered on August 11, 2021, as I was looking through the pleadings, I realized that the facts weren't actually stated in the affirmative defense under Rule 8, so I filed a motion to amend the answer to state the fact that defendant never received $900,000 as stated in the promissory note. It is important, I think, for the court to remember that this promissory note was never negotiated by any third parties. There's no holder in due course. This is simply a document between the actual parties involved in the original transaction. When I filed that motion to amend, it was opposed, and even in the opposition to the motion to amend, the plaintiffs admitted that they knew that was the defendant's position, but they claimed some type of prejudice, although I don't believe they articulated it very well. I think they said more discovery needed to be done. However, plaintiffs had already admitted in discovery and at deposition that defendant had not received $850,000, so it was unclear exactly what further types of discovery or procedure.
So wasn't the amendment here raising additional defenses that had not been stated in the earlier response in this case?
Your Honor, I think that there were defenses raised of usury, offset, and fraud.
And the amendment here is about 16 days before trial, is that right? Seeking an amendment is about 16 days before trial.
Well, at that trial, the trial was eventually took place in February of 2022. And so the amendment was filed, motion to amend was filed September 15th of 2021. Okay. And there was also, as stated, the facts were set forth in the answer, and they were no surprise to anyone. So these were legal arguments that were being made on the facts that were already known between the parties. Also on October 1 of 2021, a motion for summary judgment was filed, setting forth in a little more detail those facts and the legal arguments that they pertain to. However, at the time of the filing of the motion for summary judgment, the motion to amend had not yet been heard or decided. Plaintiffs filed a response to that motion for summary judgment. It was a full-throated response in opposition. And there was no argument that plaintiffs were prejudiced due to the fact that they didn't have enough facts or anything of that nature. In other words, all the facts were before the parties, all the facts were before the court. The court denied the motion for summary judgment because the motion to amend had not been granted. So technically, the arguments asserted in the motion for summary judgment were not pled according to the court. And then the court went on to also deny the motion to amend, stating that plaintiffs would be prejudiced, but the court stated no actual reason for the conclusion that plaintiffs would be prejudiced. Furthermore, the law says that the court's discretion is significantly limited, and that when a motion to amend is denied, they need to consider the competing interests of the parties. The court did not do that either. So other than the conclusion that there's some type of prejudice, I'm not sure why the court denied that motion to amend. The case was eventually tried before the Williamson County court. It was a bench trial. It was for half a day, and the court issued a memorandum. The court found everything in favor of the plaintiff. The court didn't even address any of the arguments that were made by my client. Those arguments were as follows. One, that plaintiffs admitted that they only gave plaintiff $850,000. In the record, there were only checks for $850,000. Previously in discovery, plaintiffs admitted that they had only paid him $850,000, but at trial, for the first time, they were taking the position that there was some magical interest or some other amount of money that transpired.
Repayment, the deadline for repayment of the loan is part of this renegotiation or negotiation for an additional amount to be provided by the lenders in this case. It extended the time period of the loan another year, is that right?
That's right, Your Honor, and let me be clear, my client has not paid back the money. And I have never taken the position that there's a total defense to this. Counsel,
the original terms of the loan here, $500,000, 10% interest, right, per year.
That's right.
But isn't that the $50,000, and isn't that consistent with the explanation that's offered by the lenders in this case? I mean, they say we extended out the payment an additional year. $50,000 is 10% of $500,000, and there's your $50,000 gap. And that seems to be what the lenders are saying. That's where the extra $50,000 is from. I mean, that seems like a pretty coherent explanation.
Well, that's not the explanation that I'm aware of. And in fact, it seems to me that there's been first off, the modification took place within a year. So a full year hadn't taken place yet at the time of the modification. So to the extent there was any interest that had already accrued, it hadn't risen to the amount of $50,000 at the time of the modification, which was only, I think, a few months after the original promissory note was October 20, 2015. The modification was February 18, 2016. Or excuse me, 2015.
The testimony from the lenders in this case, though, is that this was an interest portion, essentially, right? That the $50,000, and that's their testimony at trial, is that's the missing $50,000, is that it's interest in connection with this loan and the loan being extended. Is that a fair description of their testimony?
No, Your Honor, because they were saying that the calculation of interest there was a $900,000 principal that plaintiffs were credited for. There was not and the face amount of the promissory note and the modification was for $900,000. At the time the modification was entered into, there had not been $50,000 of interest that had accrued or could have accrued.
So what is the basis of this defense then? What is the legal significance of signing a promissory note for one amount but not receiving the full amount stated in the promissory note? What is that defense?
Well, first off, it's just an accounting of damages. Number one is that they're not entitled.
Well, but the promise is still for the amount stated in the note.
Well, and at trial,
couldn't you gratuitously say, I like that person, I'm going to sign a promissory note in their favor for $10. Could I not do that?
Just as you've stated there, I think at that point it's simply a promise with no consideration.
But this one would have had at least $850,000 worth of consideration, correct? So failure of consideration, we've eliminated that as a potential defense. So what is the legal significance of not getting the full amount you sign a promissory note for?
Well, I think number one is that it could be construed as a way to backdoor in usurious amount of interest.
Okay.
So that's number one.
That's a usury claim.
Yes.
So number one, tell me the other ones. I want to make sure we understand the full panoply of legal arguments you're making, the significance of the distinction between what I signed the note for and what I actually received.
Right. So
part of it is.
That's one is the usury, which wasn't considered by the court at all. And number two is I raised the first material breach, so the corollary terms of the agreement were not enforceable. Plaintiff has made a waiver argument in response to that. But my point is that plaintiffs never fulfilled their original promise to give my client the full $900,000. So the corollary terms of the
So
agreement.
was there an underlying loan agreement then that specified, I'm going to loan this gentleman $900,000 as opposed to $850, or, I mean, so what's the corollary promise? Where do I find that? Is it in the note?
It's in the note, yes.
Okay.
And that goes primarily to the attorney's fees. And my point is that constituted a first material breach of the contract, and therefore the remainder of the terms are not enforceable. There's that. Let's see, the other.
So where is that language in the note? Maybe that's where I'm off. Where does it say in the promissory note that the holder is loaning $900,000?
Your Honor, I don't have the note in front of me, so I can't.
Okay,
give.
I've got it actually. Can you just point me the page it's on, or what paragraph it's in?
No, Your Honor, I'm not prepared to do that. I apologize. But there is an attorney's fees provision. Plaintiffs are relying on that. And my point is that was part of the agreement. And then once they breached the original agreement under contract principles, those aren't enforceable because plaintiffs committed the first material breach by not giving defendant the full $900,000, only giving them $800,000. I'm running out of time, so I will address any questions the court has or plaintiff's arguments in rebuttal.
Right, thank you.
Thank you.
Good morning.
Good morning, Your Honor. May it please the court, Tim Street of the Williamson County Bar. Probably know two more judges that know about promissory notes than ones who had them in their practice an awful lot. But I would like to address today, first off, the denial of the motion to amend. The trial court did not summarily conclude that there would be prejudice to the plaintiffs if that were denied. The motion to amend one was never set before the court. You put motion days in, at the bottom of your motion. This motion is expected to be heard on the blank day of blank.
It was filed several months earlier, but it was not set for hearing.
It was set on a day that was not a motion day. So I go over to the court out of an abundance of caution, and there's no motion docket, and so it's not heard. So that motion was never properly set pursuant to the local rules. Local rules, you file your motion 2 weeks in advance, make sure that you get service of process 2 weeks in advance, so it was never properly set before the court. And then the appellant did not request a ruling on the motion until after the motion for summary judgment. So we have a motion for summary judgment that's raising misrepresentation, fraud, and usury that's not been pled as affirmative defenses. So the issue for summary judgment was not properly before the court. The day after the hearing on the motion for summary judgment, a letter was written to the trial judge. It said, please rule on the motion to amend. So this is 16 days before trial. This case has been going on for 2.5 years, and the court denied the motion, pointing out the deficiencies. You didn't properly set it before the court, and so it was denied.
So, Mr. Street, I know you've been at this for a while, and I would say the number one or two defense to collection of promissory note is always, well, it's either I did not sign it or it's usurious, right? So what is that's a math problem. We just go back and look and see what the maximum rate of interest that's chargeable under this particular note and see the calculation, and it's not really hard. What's the prejudice here on sort of a late asserted usury argument?
Well, I was thinking of what would be a good title for this over umbrella of what's the name of my episode today? And the name of my episode today would be Just Pay Us. If we'd been paid, I don't think we'd be here. If we were paid a less amount of interest, I don't think we would be here. But in order to benefit from the equitable defense of usury, TCA 47-14-115B provides no person shall be entitled to an equitable remedy with respect to usury or excess loan charges unless the person seeking such remedy does equity by paying or tendering into court the principal plus lawful interest in loan charges. He's never done that. So if you're going to take advantage of usury, yes, it's there, but you can't use it as a sword. You can't use it to keep from paying. Tender into court what you're supposed to do equity as the titles, as the code
So it's not
says.
really a prejudice. You're saying that really if the defense was serious, then there should have been some sort of tender offered with the amendment.
Yes.
You know, some payment was rendered. The collateral was sold for $570,000.
My clients were granted a third or fourth position deed of trust. So in order to protect their position, they had to go out and buy the previous 3 notes, have those notes negotiated to them, have the deeds of trust assigned to them so that they could foreclose on the house. So they put forth more money because if they don't get the equity out of the house, they get nothing. So that allowed them to recoup and minimize their damages, and they spent hundreds of thousands of dollars to recoup their position, to protect their position to the benefit of everyone, including the appellant.
Counsel, am I right with regard to the $50,000 that's being argued over here in this case, that the lenders are essentially saying that is part of, it's a $50,000 interest payment as part of the extension of the loan, that the loan is being extended an additional year, and that $50,000 of this is essentially interest on that loan?
I think it could be interpreted that way. What my understanding of what the parties did is the first $500,000 was given in increments, and so when they did the modification, they agreed that $50,000 of accrued interest was added into the $900,000, so they got the $850,000.
And there's also an extension of time period of repayment, right, as part
Yes,
of
sir.
that renegotiation?
Yes.
So that it gets moved a year. Is it a full year that it gets moved?
I don't recall off the top of my head, but yes, there was an additional.
In determining the amounts in this case, the judge seems to have leaned pretty heavily on Exhibit 17, and in terms of how much interest, what the amount, what the dollars are at stake. The first line essentially on that exhibit says $900,000 principal. How do we square that exhibit with the testimony of this idea that the $50,000 wasn't not given, they didn't miss a payment, essentially. Instead, it was part of this understanding about how the loan was going to work in connection with interest with the extension. How do we put those two things together?
I don't think there's any prohibition against rolling interest over into a new note and then making it print and it becoming principal. There is the bald assertion made then that the denial of the motion to amend was seriously prejudicial, caused serious prejudice to the appellant. But when we look at the findings of fact by the trial court, what the trial court found is the appellee was a general contractor that is familiar with contracts. He reviews contracts as part of his business. He read the contract in this case, and he agreed to the terms and signed the contract. That's not serious prejudice by denying the motion to amend. And finally, on that issue, the fact that it wasn't set for hearing and he only sought a ruling after the hearing on the motion for summary judgment, even though there was ample time to do that, the granting of the motion would have denied my client notice and opportunity to be heard on the motion. You know, he files a motion and he wants it to be granted without a hearing. That's essentially what he's asking this court to do. Because there was never a hearing set, we were deprived our opportunity to be heard. And really that just gets to what I suggest is the appellant's process here, and that's just delay because he doesn't have the money. Finally, he alleged usury in his motion to amend, and as I've discussed earlier, he didn't comply with the statute. So that would have been a futile motion anyway.
Is that question properly before the court, given the ruling on the motion to amend? Is the substantive question, the merits, the question of usury properly before the court?
I think he raised it later on in one of his other issues, like issue 5 or 6. But it's the same argument. I think it's properly before the court, but then the next issue was, were the findings of fact sufficient pursuant to Rule 52.01? And there must be included in the findings of fact as much of the subsidiary facts as is necessary to disclose to the reviewing court the steps by which the trial court reached its ultimate conclusion on each factual issue. As I've stated earlier, the 4 findings of fact that the trial court made: he was a general contractor, he read contracts as his business, he was familiar with contracts, he read this contract, he signed it intending to be bound by it. So, and there was no ambiguity in the contract. So I think the findings of fact are sufficient. It doesn't need to go any further. The fact that you don't like the findings of fact doesn't change that result. Third, the first material breach. I think if you're going to raise that defense, that's in the nature of an affirmative defense. So at 1, it wasn't raised, but 2, when you receive the benefit of the bargain, then you've waived first material breach. You can't have your cake and eat it too, so to speak. So when he accepted the $350,000, there was no reservation of rights. He took the money, he needed the money, and we'll get to why he needed the money in just a minute, but he waived that defense. Had he raised it in the pleadings, I would have been able to come back and say, no, you've waived that. So that was never heard. So the first material breach, I think, has been waived, and to raise it now, I believe, is inappropriate. The next issue was the trial court erred by not admitting parole evidence. That issue fails because it's clear that both the promissory note and the modification to it are fully integrated contracts. There's no reason to go beyond that contract. The argument being, well, we only got $850,000, therefore we need to admit parole evidence to show that. The court did not agree with that, and there's a legal basis for not agreeing, and that is both of those documents were fully integrated. There was no reason to go beyond them, and the court didn't do it. The fifth issue is that there was impeachment of a prior order that was offered as impeachment evidence against Mr. Arab. And the reason Mr. Arab needed this money in the first place is he had a big construction project and his financing fell through. And so he had to come, so he didn't have to, but he came to my clients seeking the additional funding. He sued his prior financier, and in that trial court, in that case, the trial court, I'll not read a whole lot of it, but a good example was he was impeached with evidence of prior inconsistent statements, and most fatal to his credibility, material averments in his verified complaint were proved to be untrue. Now, I offered that as impeachment evidence under Rule 608A, and that was properly admitted. That was properly admitted for 3 reasons. 1, he opened the door. He said, well, I've had a contract that fell through and I had to get some money from somewhere else. 2, he used that order to refresh his recollection. And 3, it was used to attack his credibility for truthfulness. So the argument that was substantive evidence was used versus impeachment evidence, I don't understand that argument really, but there's no case law cited, no statute cited that you can't, that was used as substantive evidence. In fact, it was used as impeachment evidence, but even if you just take that out of it, the court didn't rely on it in reaching its decision. reached his decision because he was a general contractor, familiar with contracts, read this one, intended to be bound by it. Finally, back to the usury, and this was the final issue raised by the appellant, and I rely on the same statute that I cited earlier. If you're going to rely on usury, if you want the equitable defense of usury, you must do equity. And we're still waiting to be paid. He's not done equity. He just doesn't want to pay. Thank you.
Thank you, Mr. Street. Mr. Waltharth?
Your Honor, I'll run through and address some of the points made by opposing counsel. With regard to setting the case for hearing, this was during COVID. It was set for hearing. My recollection is, and this is not in the record, but I called the court and wanted to get a ruling on the motion, and I was told that they would do that on the pleadings. So I wasn't arguing motions over the phone. That's how that came to be. The statute relied on by Mr. Street is Tennessee Code Annotated Section 4714-115. It says, no person shall be entitled to an equitable remedy with respect to usury or excess loan charges unless the person seeking such remedy does equity by paying or tendering into the court the principal plus lawful interest, and goes on. I'm not seeking an equitable remedy here. I'm seeking a calculation of damages here. That doesn't mean that if Mr. Street's argument were correct, credit card companies could charge usurious rates if people couldn't afford to pay their credit card bill. That's not what the law is.
What, if we do get to your usury argument, what rate was appropriate on this note? Was it the formula rate would have applied to this, or some other rate?
That's right, Your Honor, and I set that forth in my motion for summary judgment, a calculation of how it was usurious. I also want to address Exhibit 17. That's exactly the issue, is that the $900,000 was always calculated as principal, plus an additional rate as set forth in the note and the modification. I would point the court to the fact that the modification of the note did not change any of the interest rates that were applicable to the principal. The interest accrued during that entire period. The $50,000 is a phantom amount that came out of a recitation of what's on the face of those promissory notes. And the court's findings of fact did not include the subsidiary facts necessary to figure out where that came from. And I even asked the court in my motion for revision for an explanation of how it got to that number, and my motion was denied. So here we are, still wondering where that is. And the court can't figure it out, and that's why the court is questioning the attorneys, and that's why Mr. Street is, I can't remember the word he used, but he's assuming, or that's how the court, I presume that's how the court got there. The court has to say how it got there, and it didn't do that. You're right, it was a math issue. There's no prejudice here. With regard to the legal, the first material breach argument, okay, did I say those words in the pleading? No. Did I plead the facts? Yes, I pleaded facts in the proposed amended answer as to exactly what the defense was, that he never received the money. States that. So the gravamen of the defense is there. The legal label, respectfully, I believe is immaterial. It's not magic language used. It's whether he's prejudiced, whether he's put on notice of my client's defense. And
doesn't the legal label matter, though, significantly? If the parties can agree to $50,000 in interest being wrapped into the amount owed versus they can't agree to it. It's a usurious amount. Doesn't the label matter a great deal?
Well, the label matters when we're reviewing it, but what I'm saying is the plaintiffs were not prejudiced because they were aware of the facts on which these arguments were based. For purposes of pleading, notice pleading, was he on notice of my client's position going into the trial? And he was.
All right. Thank you, Mr. Waltharth, and Mr. Street for your arguments. We'll take the matter under advisement.